Be ready. 5 seconds.
The ambit of the jurisdiction of the court to reject a plaint under Order 7, Rule 11D of the Code of Civil Procedure on the ground of bar of the suit by limitation and the validity of the impugned order passed by the court below, deferring the adjudication in this regard to the time of hearing of the suit are the primal questions involved in this revision application. In view of the principles above mentioned and taking the averments made in the plaint to be true and correct on their face value, the order dated 18/8/87 passed by the DCLR appears to be without jurisdiction and nullity. The facts mentioned in the said order of the DCLR and also those raised by the defendant first set in his petition under Order 7, Rule 11 CPC cannot be considered at this stage. In order to successfully sustain his objection that the suit is barred by limitation with regard to relief number C, which according to him is the main relief, the defendant first set will have to plead and prove by leading evidence in course of hearing of the suit that the plaintiffs were in fact intermediaries and the suit properties were included in their intermediary interest over which the defendant first set had been granted a permanent lease by the plaintiffs and the same had vested in the state of Bihar under the provisions of Bihar Land Reforms Act 195. The relief number C, as prayed by the plaintiff, is held to be of no consequence. To conclude, it is held on the basis of foregoing reasons and discussion that the suit with regard to relief number C supra cannot be held to be barred by limitation on the basis of averments of the plaint, and consequently the plaint cannot be rejected under the provision of Order 7, Rule 11D of the Code of Civil Procedure. The impugned order does not suffer from any illegality or jurisdictional error. The civil revision application is accordingly dismissed. However, it is made clear that the observations in this order have been made for the limited purpose of adjudicating the prayer under Order 7, Rule 11 CPC and shall not in any manner prejudice the cases of either of the parties at the time of hearing and final disposal of the suit. In the facts and circumstances of the case, there shall be no order as to costs.